work. This was fine.
Before the short term, my Lord Justice Phillips, or no, maybe the Lordship asked me about commissions. It was the Lordship that asked me about commissions. And I have looked into it. There is no direct evidence that was called at the trial to deal with the question of commissions at all. There was a hearsay statement made by my client in answer to some cross-examination, but no more than that. So it didn't raise its head. So far, that is as concerns the customer's awareness or otherwise of the salesman earning commission. It's fair to say that the broader question of commission was explored at length by my learned friend with my client in cross-examination, but that's a different issue.
Right. Okay. Thank you. I think it was my Lord's question, but anyway, you answered it.
I just couldn't remember.
Oh, well, don't worry. Don't worry. That's fine.
I was going to take your lordships, my lady, to some of the cross-examination to identify fiduciaries. And before I do that, I wanted to draw your attention to one passage in Mr. Ioanou's cross-examination, which in the paper transcript bundle, electronic one, if it has now arrived.
It has arrived over lunch on email.
I'm glad to hear that. I know that my old friend Mr. Nathan asked us for a copy, and I've failed to get one to him. That's being seen to at the moment. I know that he's got a laptop in court anyway, so. Oh, he has. I'm so sorry. At any rate, I'm sure it's on its way. Mr. Ioannou was, if I could take it to 1142 in that document. And highlighted on that page, and it starts at line 21, page 79 of day 23.
Is it in the extracts as well?
It's in the extracts, yes. 1142. My learned friend asked him this question. Now let's look at paragraph 6.1.10. These are setting up the duties and obligation of ROP UK, and this is what ROP UK was obliged by the contract to do for Alpha Panareti, which was to use its best endeavours to carry on the business and to achieve the maximum possible sales of units having had to the present sales. In other words, they were to act as, for the purpose of obtaining all things necessary to obtain sales, the best extent possible for Alpha Panareti. Again, these people, they were independent entities. They were working for their own best interests. The answer was, again, these people, they were independent entities. They were working for their own best interests. As I have mentioned on Friday, I have given them a DVD. That's why I answered the question to the Lordship with regards to brochures. But I wasn't looking to see any brochures because they told me, all these people, they were coming from their database, customers of theirs who were seeking purchase properties abroad. So therefore, in this paragraph that you were referring to, is clearly they were working on the best interests of their own, which is necessary since they had a relationship with AP, is good in terms for the AP 2. Right, and for whose benefit were they seeking to obtain sales? Primarily for their own benefit, and then anybody else. Who is anybody else? Answer AP. So that was how Mr. Ioannou dealt with the questioning that he was asked about the nature of the relationship between Alpha Panareti and the agents, and of course picking up on those passages of the service agreement between Alpha Panareti and ROP UK, dated July 2007, which we were looking at a little bit before the short adjournment. Going back to the fiduciary relations between whom, if I can put it that way.
Well, before you do that, what if anything, do you seek to make out of that passage that you've just shown us? What is the purpose of showing it to us?
The purpose, my lady, is to point out, to flesh out by reference to the evidence the point I was making at perhaps excessive length before the short adjournment, that this was an agreement between the salesman and Alpha Panareti, which the prime motivation behind it was to get the agents to introduce customers to Alpha Panareti. And that's how Mr. Ioannou of Alpha Panareti also understood the position to be. Regardless, perhaps, of the strict words of the contract, he
says that they were acting for themselves, not for Alpha Panareti.
Well, they were acting for themselves in as much as they were earning a hefty commission for the introductions that they were effecting. But his evidence, at least, was not quite as stark as the propositions that were coming to me from the bench, if I can put it that way, shortly before the short adjournment. Namely, that it's quite clear to all concerned that what the agents were being sent out to do was to persuade as many people as possible to sell as much as possible.
I am slightly struggling with this. Insofar as the contractual relationship is concerned, that is as set out in the agreement.
Yeah.
So how is this advancing that, this evidence? Are you saying this is addressing some other issue?
Well, what I'm saying is that it provides an understanding of that part of the agreement which said that the obligation of the agents was to promote and to, I'll get the words of the agreement out, to promote and introduce potential clients to the developer.
Why is Mr. Ioannou's evidence relevant to that? What he thinks subjectively?
His evidence is relevant to that in this regard, that it is the case of the defence, and I'll seek to develop that during the course of this afternoon, that the driving force, irrespective of the words of the agreement, the driving force of the transactions that took place and the way in which they happened came from sources other than Alpha Panareti, namely that ROP UK was effectively running the show and running the agents, and that so far as the obligation to explain or put forward information in relation to the mortgage was concerned, that was exclusively the obligation of the bank. And Alpha Panareti, as I said to your lordship earlier, was the developer whose obligation was to build, and the mortgage element of the package was not his department, if I can put it that way.
Well, it was part of the package that he was seeking to use in order to attract people to purchase off the development.
I can't dispute that.
No.
Well, it was called the Alpha Panareti loan.
That's a label, my lord, I would say. It could have been called, and what it actually amounted to be, which was the loan which you can use to buy an Alpha Panareti property. But that's rather more cumbersome.
Right, where next?
So far as the fiduciary relationship between the agents and whom is concerned, you need to see. You've seen that of the comment of Mr. Williams in his cross-examination just before the short adjournment. There are 5 other passages to look at. Mrs. Gillespie, who was one of the sample claimants, my lords, my lady, will find at page 310 of the paper extracts. 310.
Is it being contended against you that there was a fiduciary obligation between the agents and the AP?
It's not being contended against me in terms that there was a fiduciary relationship between the agents and AP, but what I have been seeking to do was to identify the absence of those various characteristics of a classic agency, to which I drew your ladyship's attention when I looked at the authorities before the short adjournment.
I was just wondering to what extent this was disputed. Because if it isn't disputed, then we may not need to spend time looking at transcripts in order to make a negative proposition.
Well, that perhaps is harder for me to answer than it might be for my learned friend to answer.
Well, Mr. Nathan,
Well,
what's the position?
my lady, what we say is that however you care to look at the relationship, whether it is simply limited to, for present purposes, to authority to present and promote and sell to the best of your ability and get sales in to the best of your ability, one form of authorization. Alternatively, if it is to be characterized in some kind of traditional agency way, which I don't think really is apt, but nevertheless, one needs to canvass that because it's been brought forward by my learned friend as part of his arguments. We say, well, if you really have to show that there was a fiduciary relationship, then all that you need to show is loyalty. They were to act in the best interests of Panareti and not in their own personal interests. And that's enough, so far as fiduciary, because that brings about the necessary fiduciary obligations. It's as short as that. But the authorities show you don't even need necessarily to have fiduciary relations in this kind of situation.
Well, we saw that this morning.
I hope that.
Thank you.
The passages I tend to go to are short, but what they do demonstrate is, in my submission, an existence of a fiduciary relationship between the salesman and the customers, and I submit in those circumstances must surely negative the existence of a relationship so defined as between AP and the customers. And whilst, as of course we've seen this morning, that of itself does not mean that they are not agents in the classic sense, it is one of the factors to take into account in determining whether or not they are agencies, and its absence is a point against. So, taking it as quickly and as briefly as I can, Mrs. Gillespie at page 310 of the bundle, transcripts bundle, internal page 41, line 14, she says she thought that Mr. McCormick, who was the salesman speaking to her, said, I thought he was very trustworthy. I was going to say you've grown to trust him, but I think you've answered that question, yes. Did you regard him as the person who, in this whole transaction, were you to go ahead and decide to go for it, was the person who would protect your interests? Yes. It was your interests that you were satisfied he was concerned with, rather than Alpha Panareti's, is that right? No, well, as a financial advisor, I was thinking that what he was telling me and basically selling me was in my interest, yes. So he was more than merely a salesman as far as you were concerned. Yes, he was your trusted advisor, yes. Then, so far as Mr. Gibb is concerned, if you turn on to page 345, which is in the hard copy, just a page over, I'm picking it up at line 4. At the time, and his agent, I think, is also at the time, did you trust him? Yes. Did you expect him to give you the best advice? Yes. Did you expect him to be loyal to you and your wife in relation to the work he did for you? I did. Mr. Joyce, page 404. Internal page 47, at line 10. Question, the fact of the matter was that he was your trusted advisor, he was your independent financial advisor who had arranged all your financial affairs, hadn't he? Correct. You looked to him to act in your best interest, didn't you? Absolutely. And finally, Mr. Harrison, page 829. Up at line 2. Mr. Whittaker is your financial advisor, is that right? Yes, that's correct. How long have you been using him? I don't recall, to be honest, over 5 years. I think he looked after your pension, you say. Is there anything else he was looking after? If you know that was it, no other assets, no other insurances, no, but you trusted him, yes. And you looked to him to look after your interests, helping you to decide what was best for you as far as your investment intentions were concerned, as far as our pension was concerned, yes. And so far as what turned out to be the Cyprus proposition as well, I trusted him, yes. And you looked to him to look after your interests, I suppose. I mean, you wouldn't have expected him to be going out of his way to advise you invest in something which was plainly mad to invest in. Answer, no. And you wouldn't expect him to be giving you advice in such a way that he would be feathering his own nest ahead of your own interests, would you? No, I wouldn't have done, no.
All that goes to show, maybe goes to show that the advisors were in a particular position of conflict. Doesn't show, but showing that they may have owed a pre-existing duty or fiduciary duty to the customers doesn't mean that they weren't, in this instance, also acting as agents for Alpha Panareti and being paid a commission by them, which, as we've seen, doesn't appear to have been disclosed.
I have to accept all of that, my lord, and that's plainly a distinct possibility. But the reality is that what I'm seeking to establish is that if one looks at the checklist, if I can very loosely call it that one gets derives from the authorities that I mentioned earlier, all the indications are that so far as a fiduciary relationship between principal and agent is a prerequisite, and I appreciate it doesn't have to be in all cases, but insofar as there is a requirement for it, more often than not, then the evidence would tend to point in the opposite direction in the case of these these clients.
The difficulty is that it doesn't sound as though they even were aware that the financial advisors were under any arrangement with Alpha Panareti. So, given that, it doesn't help us, does it, as to their understanding of or what the nature of the arrangement was. So I'm not sure where it takes us, other than it possibly makes the advisor's conduct even more egregious.
Well, insofar as it does make the advisor's conduct more egregious, it's not an egregiousness that, in my submission, can conceivably be laid at Alpha Panareti at all. If the fact is that they're going off on their own and behaving in a conflict situation, possibly, as your lordship posits, or they are willfully not disclosing a commission that, in other circumstances, were this a territorial financial services transaction they would be bound to, then that undoubtedly doesn't look good for them, if I can put it that way. But that hasn't got anything to do with Alpha Panareti.
Well, on the contrary, the passage from Mr. Ioannou that you showed us shows that he knew perfectly well. Indeed, it was part of the scheme that the salesmen would be people with whom the customers had an existing relationship, who were trusted by the customers, and they were sent out to market this terrific deal without being told to tell them about the risks.
Well,
that brings it very much, on the brief passage of Mr. Ioannou's evidence you showed us, it brings it very much home to Alpha
Well, I would say no. I would say that the passage that I showed you from Alpha Panareti does no more than to demonstrate that the true meaning of the arrangement into which he entered into with ROP UK was that they would introduce their client list to Alpha Panareti for the purposes of the sale perhaps taking place, but no more than that.
Well, on this question of commission, you might want to look at a case called Wood and Commercial First Business, 2021 EWCA Civil 471. It's possible that it has nothing to do with this case, but I have a vague recollection of it, and it may possibly have some bearing. I don't want to give you unnecessary homework, but just have a look and see if it helps or not.
Well, I'm very grateful. I'll take the opportunity to do so at the first available opportunity. The next element of the what I rather loosely and inelegantly call the checklist was the lack of any real control over the activities of the salesman on the part of Alpha Panareti. Heavy reliance is placed in my submission in the judgment on the various training seminars that took place over time at Alpha Panareti's premises. And to that extent, they do merit some degree of scrutiny. So far as documents evidencing the way in which the training and so forth was put together and conducted, can I ask my lords and my lady to look at a few of these? Turning to the supplemental bundle, and I'm sure it will be in the second half of it. First, at page 460. Now, this is quite early in the history of the Alpha Panareti sale. Of the sample claimants, only one had so far put pen to paper in relation to a property in the St Nicholas development and two properties in the St George Hills development. The rest were yet to contract with Alpha Panareti. It's the 17th of April 2006, and this is ROP UK emailing all the salesmen on its books. And the second paragraph of that in my submission is relevant. It says, our UK offices, that's ROP UK's, will be working from new premises from next week. The new offices will incorporate a purpose-built training room, and this will allow us to train more agents in the Cyprus selling processes, including tax mortgage documentation, as well as our software. We intend to publish a training event schedule soon to allow you, that's the agent, to plan when it would be convenient for you to book your place on our one-day training session. Our local hotel will accommodate you, etc., etc. So, from an early stage in my submission, it's ROP UK that is taking control of the training process. Now, I'm not going to dispute the fact that Alpha Panareti attended some and of these training exercises, and indeed contributed to some of these training exercises. But at the moment, I'm focusing on the question of control. And right from the outset in my submission, it appears that ROP UK were exercising that element of control. If my lords and my lady turn on to page 464, that is a document dated a week or so later, 24th of April 2006. It was a document that, as I understand it, emanated from Miss Brown or Mrs. Wellesby, one of the agents who was called on behalf of the claimants. And it was one more of the documentation that was generated for the purposes of training. And one sees there the mortgage loan process being spelled out. And I don't need to take you through the entirety of the process there. It's there to be seen. It says what it says. But the importance of it in my submission is that this is something that is part and parcel of the training process that is being orchestrated and controlled, I would say, by ROP UK. And there is nothing there to suggest that there's anything misleading or inappropriate that is being communicated to the agents for the purposes of their passing on to their clients what the mortgage loan process will be in their presentations to clients to introduce them to Alpha Panareti. And so that, once more, insofar as you're against me with regard to the existence of a duty, I'll be submitting that the duty was simply a duty of fair presentation, a Headley Burn duty, and this exemplifies exactly that in my submission. That it tells it how it is so far as the process is concerned, and there is nothing objectionable, misleading, or false that can be said about it.
Trying to understand this document. In the first bullet point, it refers to mortgage loan is applied for on your behalf.
That was by Alpha Panareti. It's common ground.
So can I understand who is this being addressed to?
Well, as I understand it, it's a document that is generated for the purposes of the training of the agents to enable them to explain to the customers how the process will work.
You, in this document, is the customer.
In this document,
whether the document is provided to the customer, or whether the salesman is being told this is what you say to the customer, you must be the customer. See, for example, the 5th or 6th point outlines the terms in Swiss francs as the Cyprus pound loan is converted to reduce your rate of interest.
no, I accept that entirely.
Yeah.
Yes.
And yet, the 5th bullet point refers to the purchaser.
Which is, as I say, I'm only repeating what I say, that it's a training document. How how it is then utilised, I don't think the evidence reveals.
So this was a document given by ROP UK to the people they were training. Is that right?
So I understand. Yes. So I understand the position. And it's part and parcel of ROP UK taking control of the process. And one sees it again, their control of the process, that is. Moving on to the following page, 465, and on to 466, which is ROP UK once more, centrally, writing to the salesmen, selling agents, and it's dated the 31st of July 2006. By the 31st of July of the sample claimants, another three have, as it happened, signed up by this date. I've started to write this update whilst on my family break. I've had many meetings with some of our clients, Alpha Panareti, Alpha Bank, KPMG, solicitors here in Paphos, and then there's material about a development award, there's a VAT update, and then over the page at 466, the author, Mr. Madison of ROP UK, says this: there's a new interest-only mortgage option. Alpha Bank has announced that they have developed an interest-only mortgage product. We are currently negotiating a special deal for ROP agents. This reduces considerably the monthly commitment. Full details are being prepared for us, and we are to modify the ROP system to show both interest-only and capital repayment options within our quotations. You, the agents, will need to select the mortgage repayment option when reserving the property. And then he goes on, changes to Alpha Panareti purchase agreement. Following feedback from some clients and agents, along with our own observations, I have been able to draft a purchase agreement for only ROP clients. The new agreement offers a greater level of protection, and so forth. And then next, changes to solicitors' general power of attorney. This document was very general, had far-reaching implications for some clients, and therefore this power of attorney has been edited to relate to service on the client's behalf that relates to property purchase in Cyprus with Alpha Panareti. And then he goes on to matters to do with functionality of the software. But then he finishes off on page 468. Also, I have spent, right at the foot of that page, I have spent many months reconciling your clients' financial transactions with Alpha Panareti and have agreed the figures with a couple of small exceptions so that we communicate with the clients, knowing that the figures are agreed with Alpha Panareti. The exchange rates being used now in the ROP system going forward today have been adopted by everyone involved. We've also been able to recruit more agents, and Alpha Panareti will be sharing with us 2 new developments that are ours to sell in the future once we get St. George Hills sold for them. And he mentions a sales convention that's going to take place in Paphos. But again, the message that's coming through loud and clear is that control of the marketing exercise, control of the drafting of the documentation, the negotiation of the deals that need to be put in place in order to put the package together, if I can put it that way, is all being driven by ROP UK. And again, for the purposes of the submission I make as to classic agency, the question of control is a relevant one. Likewise, the question of the reality of who it is that is pulling the strings. Well, I mean, it's the same point. It's pulling the strings of the agents at the material times. And then I can move on finally, so far as training documents are concerned, to 543. And this is a document understood to have been drafted in about May of 2007. And once more, it's a document that emanates from the agents. In fact, one sees on this particular copy the marking HB14, and that's Miss Brown, Mrs. Wellesby, as she was by the time of the trial, who was one of the agents concerned. And this once more is a draft letter produced by ROP UK for the agents to write to their clients. Thank you for trusting me to purchase your new off-plan property in Paphos, which will be constructed by Alpha Panareti. I would like to confirm receipt of your deposit, which will be banked into Alpha Panareti's bank account as soon as possible. Next paragraph, I've made the reservation until contracts have been drawn. I'll look after your purchase within the program. Reference to reservation form and the penultimate paragraph of page 543. We have, and that's ROP UK, have agreed very favourable terms for the conveyancing. And then up the next page, 544, second paragraph, Alpha Bank, who are arranging your mortgage loan, will respond directly once you've been approved within their process, subject to the mortgage application form, which will be sent to you with your mortgage offer. Alpha Banks agree to open bank accounts. We recommend you bank your sterling deposit using the Alpha Panareti bank account in the UK, as exchange rate negotiated much better than we can do individually. And then it talks about the next stages of the transaction. And in the penultimate paragraph, the information we have supplied during the process is as accurate as we can make it until you receive the actual documentation of all parties. However, it should give you enough information to confirm what you have bought, how much deposit is required, what you are funding via the Alpha Bank mortgage, and how much is expected once the property is built, should there be anything else you require, etc., etc. Again, so it's driven by ROP UK. It's identifying here that it's Alpha Bank that are behind the mortgage product. And it identifies finally that which I submit as part of my second essential proposition, which has rather melded into my first, namely that this is an information case. This is an execution only type case. It's not an advice case. It is saying, here is the information. This is what you need to know in order to decide whether you want to go ahead or not. But we're not advising you as to the pros and cons of it. We're not advising you as to whether or not the mortgage is or is not a sensible transaction or clever transaction to go into. We're not advising you as to whether the apartment that you've chosen has one that has got a particularly nice sea view or not a particularly nice sea view. We're not advising you as to whether or not the apartment or the villa or whatever else you've chosen may or may not actually end up being built on time or whatever.
Well, there are two separate points. One is whether advice is being given or it's a relationship which involves advice, as to which it might be significant that the penultimate paragraph concludes by saying, if there's anything else you need to feel totally comfortable, then contact us. And the second question is, if it is, whether the advice is being given by or on behalf of Alpha Panareti, or simply by ROP UK on their own account.
Well, in taking those two questions in order, in my submission, there is nothing in this document, and I would submit in any of the other training documents that we've seen so far, that indicates that advice was being proffered by the agents, and that actually the should there be anything else element in the penultimate paragraph there is no more than the words of comfort that a friendly letter will have. Here's everything you need to know, but of course if there's anything else you want to know, get in touch.
Well, if you're doing execution only, you don't start off by saying, thank you for trusting me, do you?
There's nothing completely conventional about the way in which these transactions have been put together.
Well, I think that's probably what informed the judge's conclusion. This wasn't a conventional execution-only situation. These were trusted advisors of these individuals who were putting forward these products to them, saying, "Trust me in relation to this transaction." And if you need anything else to feel comfortable with, seems to be there's ample basis to just. What we've got to be satisfied is here is the judge got it wrong. The material you're showing us seems to suggest that, or anything else, he was entitled to form the view from this material that there was an advisory relationship was in place.
Well, in my submission, there's nothing to suggest that the relationship between the agents and Alpha Panareti was such that Alpha Panareti was either instructing or authorising or expecting the agents to go out and advise. The relationship between Alpha Panareti and the agents was one that expected them to go and demonstrate and to provide the information upon which a decision would or would not ultimately be made.
So effectively saying when they're going further here, they're on a frolic of their own.
Well, that in a sense goes to my Lord Justice Mill's second question, which is that it is ROP UK that is driving the process. It's ROP UK that's driving the process, both in terms of the correspondence and the documents that we've already seen, and in relation generally to the evidence that we'll see in one moment about the salesmen's view themselves of the training exercises in which they carried out.
And Mr. Ioannou thought he had a great product, and the judge says it's not a case of fraud; it's just a case of negligence. And Mr. Ioannou, who he didn't treat him as a dishonest witness. On the contrary, he said this was a product of which he still feels proud. So why wouldn't somebody who thinks they've got a great product encourage their salesman to go out and spread the message?
Well, indeed, but I'm not for one moment suggesting otherwise. The question is, what's the message that they're spreading? And there's a significant difference in my submission between a message which has within it a component which says, tell them all that's good about this, hide from them everything's bad about this, and advise them to go ahead on the one hand, and on the other hand, a message which says, here are the facts, put it to them. And in my submission, we're in the latter territory, we're not in the former territory. And I'll go on to say, but if and insofar as facts were put to the agents that for one reason or another then weren't communicated to the customers, then that's something that shouldn't properly be laid at the door of Alpha Panareti. And I'll draw an analogy when I come to it between the findings that the judge made in relation to the VAT issue that you'll have read in the judge's judgment, which is obviously subject of this appeal, I should say. But the VAT issue was found in Alpha Panareti's favour, and in my submission, it's analogous to what has happened, or what may very well have happened in relation to the mortgage, if it is the case that information in relation to the mortgage was kept from either the agents, and we would say in that case by the bank, or kept from the customers by the agents. I'll come to that in a short while. I wanted to tell your lordships, your ladyship, what the agents themselves had to say as to the the ROP UK control so far as the training sessions are concerned, and moreover what it is that they were, what they took away from the training sessions, and you'll have seen from my skeleton argument that I've focused very much on the fact that the training sessions were not, we would say on this side, the all-encompassing Alpha Panareti at the centre of it, telling everyone what they did, what needed to be done, and directing everyone left, right, and centre, and taking control of the sessions. It was very much a situation of sessions being organised specialism by specialism, so that you would have representatives of Alpha Panareti at the training session saying, well, these are the buildings, this is the site, this is the build progress, etc., etc. These are whatever else that they might do in relation to the build, and there'd be lawyers attending, so that they can explain to the salesman how the legal processes in Cyprus were going to work once the clients had signed up, and you had the bank who were giving a presentation on the mortgage product. So if I can take you to the evidence first of Mr. Heath, and you'll find him at it's in the transcript bubble. I thought I'd made a note on page number 10. Foolishly haven't. It's day 26. Not possibly right. I'm so sorry. Day 13, I should say. Internal 562. I'm very grateful. 562. Thank you very much. Is that right? Almost not quite.
There's something about training on 564. Is that what you want?
No, it's 583. I think that I'm after. And what Mr. Heath, and he's talking there about a training session, is internal page 92, picking it up at line 11. He said, in answer to an earlier question, Alpha Bank should have had a duty to state all about the problem with the Swiss franc. They never did. Question, and if the Alpha Bank breached its duty to state all the problems to do with the Swiss franc, then how, so I understand what you're saying, is that Mr. Ioanou's or Alpha Panareti's fault? Answer, he had a close connection with the bank. So if I have a close connection with someone who does a bad thing, am I responsible for the bad thing they've done? If you're the director of the business, yes. Is Mr. Ioanou a director of the bank? I don't know, but we believe. Are you speculating that he is the director of the bank? No. Can you explain how it is that he's responsible for the bank's defaults and errors? You can't, he isn't, I can't explain. So Mr. Heath was clear that so far as providing training on the mortgage product, including, if necessary, advice as to the merits or otherwise of it, that was Alpha Bank's role within the training process. Mr. Shaw, on the same day, I'm sorry, mate.
I must say, I feel there is a great danger of island hopping here,
Yeah.
and some of the islands seem to be desert islands. The judge had a 29-day trial in which he had all this evidence and was thoroughly immersed in it, and made the findings that he made.
Yeah.
Shouldn't we be working on that basis and seeing whether they are tenable in law? It's a bit hard to say that he wasn't entitled to make those findings on the basis of dipping here and there through hundreds of pages of transcript.
Well, I understand that, my lord, and it's not perhaps the most satisfactory way of going about things, but the reality is that whilst we may to some degree be island hopping, the islands, so far as they're not barren ones, don't appear to be ones that figured on the judge's radar. And in my submission, they should have done. And had they figured more significantly on the judge's radar, in my submission, he ought to have come, we would say, to properly have come to a different conclusion. The conclusion being that it was for the bank it was the bank that was responsible for the training that the agents got in relation to the mortgage product. He found that it was Alpha Panareti's responsibility.
My point, I don't see how Mr. Heath's view about whether Alpha Bank should or shouldn't have explained it doesn't seem to me to matter anywhere.
No.
Well, his view doesn't matter, but what his evidence is directed towards is the fact that what is coming to him in relation to the mortgage product is from Alpha Bank.
Was he asked to comment on the fact that the loans were described as Alpha Panareti loans in the publicity material?
I can't.
Because that seems to me might have made a difference to.
I can't
his
off the
view.
top of my head answer that question.
That's the trouble, isn't it, with this type of exercise?
It is the trouble.
And we're looking at what you asked him in a snapshot. Doesn't seem to me it's, as my lord has already said, I'm not sure where it can take us other than to, well, I'm not sure where it can take us.
Well, when I say even the snapshots take you, it is the fact that there is consistency between the agents to the effect that that it was the bank that controlled the process so far as the information that they were getting regarding the mortgage.
Well, I have to say that maybe this isn't something that was gone into, but I have to say that I'd thought many customers being told that there was something called an Alpha Panareti loan, which Alpha Panareti had arranged with Alpha Bank, might well think that was an arrangement between two entities that, if they were not connected, were certainly working very closely together to produce this special product for Alpha Panareti customers, and that Alpha Panareti, when they devised this exclusive product, would have been doing it specifically for the purposes and interests of their customers. So the attempt to split it off and say, oh, well, the mortgage was all for Alpha Bank, I think completely ignores the way this was being presented to the purchasing public.
Well,
that's what the judge found, didn't he?
Well, certainly the coincidence of names is not something that either was mentioned or was taken.
Well, I don't think I specifically said coincidence of names, but it's certainly the overall picture given is that Alpha Panareti was working hand in glove with Alpha Bank to produce for a bespoke product for their customers.
Yes, but the product is the bank's product, and ultimately it's only the bank that's in a position to be able either to explain the product properly, or if advice is required, to advise on it.
It really doesn't follow. If it's a bespoke product and two people have input into it, then the bank's customer, in this case Alpha Panareti, would be expected to understand the product that it had asked the bank to produce, because otherwise it wouldn't be a bespoke product. And therefore, whether or not the bank would also have an obligation to explain it, it doesn't necessarily follow, as night follows day, that the bank's customer wouldn't also have an understanding of it and be able to explain it to its customers. And in fact, one would expect that it would have a very good understanding of it, because they would be the first person to whom the customer would turn, because the front-facing salesperson is the person who's actually the link between them. And so they would go to the agents, in inverted commas, whether they're real agents or not, the salespeople, and say, well, tell me about this wonderful mortgage. They wouldn't be going off to the bank to ask them. It's unrealistic.
Well, Milady, with respect, I wouldn't quite put it that way, for this reason, that if one's being realistic about these things, it's unrealistic to expect the developer to go to the bank and say, provide me with a mortgage product. I need it to be able to do X, Y, and Z. It may be that you'll think about, you might want to think about using foreign currencies because that might achieve a particular result or what have you. That's entirely unrealistic. The realistic scenario, surely, is that the developer says to the bank, is there a product that you can either create or have on your books that I can tell my potential purchasers it is available to them should they wish to go with me.
And it has certain advantages which I can use as a bolt-on for my sales pitch.
Well, not necessarily. I mean that isn't necessarily.
Come on, Mr. Parker. We really have to look at this from a commercially realistic perspective and not angels dancing around on a pinhead, with the greatest of respect. All of this sales and marketing material is designed to get punters to sign on the dotted line for this particular development. And part of the sales pitch is promoting this particular financial product. And it's just unrealistic, with respect, to suggest that the developer is sitting there with his head in the clouds, having no idea of what this product is, and saying, well, you've got to lay that all off onto the bank.
Well, it is realistic to say that if you need to know about the detail of the product, if you need to know what the upside of the product or the downside of the product might be, then you need to speak to the bank about it, because it's their product, and that's not unrealistic by any means.
Well, the bank, it's not the bank who's selling this product into the United Kingdom, is it? The bank, it's your client who's got the agency agreements with UK agents who are going to sell to UK customers. As far as the bank is concerned, maybe you are going to sell this to Swiss customers.
Well, so far as the bank is concerned, what it's going to do is its product will be sold, and no doubt the bank will have taken care of its own interests in ensuring that when the product is sold, the bank won't lose.
Maybe the bank had a duty as well. I mean, the bank was the defendant to all these proceedings, and it's settled, hasn't it?
Well, indeed, and those details I'm afraid I'm not completely privy to. But what I can say is that it's exactly that brings the bank into sharp focus, because it is the bank's product. It is the bank that will be entering into a financial transaction with the punters. It is the bank, no doubt, that will be looking after its own financial interests in selling that product, which is why it is in my submission too simplistic, and the judge, with respect to him, was seduced into the simplistic view that Alpha Panareti mortgage means there's this wonderful thing that has the Alpha Panareti label on it. Alpha Panareti mortgage, in fact, means no more than the bank has a product which is available for you to use to buy an Alpha Panareti product.
Well, I think that's a very, very tendentious analysis of that phrase. I'm afraid I'd have thought any reasonable customer would think that this was something which was specifically designed with input from Alpha Panareti for the benefit of their customers, for the particular circumstances of the developer and the customers, and the bank was simply providing the money, but that it had been tailored by Alpha Panareti. And I think if a company puts its name on a product, they bought it, if it's broke, they keep it. Well, I don't see how you can label something like that, say that it's something we've negotiated exclusively for our customers, and then turn around and say, well, actually, everyone would have understood that it was simply a mortgage to buy one of our properties. Well,
is there in fact anything special or exclusive about it? I mean, it's just a loan in Swiss francs secured on property in Cyprus, isn't it? Is there more to it than that?
I'm not sure there is, to be perfectly honest.
I mean, in what sense was it exclusive? Was the bank not prepared to lend money in Swiss francs to other people?
There is a difference between the learned friend and me. I think it's argued on behalf of the claimants that there was indeed a genuine exclusivity of this particular product only to Alpha Panareti customers, and that if nothing else is evidenced by the brochures which said this is our exclusive mortgage deal. Against that,
Clearly it was packaged and presented in a certain way, but I'm just wondering whether in fact there was anything which the bank was prepared to do for Alpha Panareti or its customers which it wouldn't do for anybody else.
Well, against that is the evidence of Mr. Papakristou from the bank, who gave evidence right at the conclusion of the trial, saying this wasn't exclusive to Alpha Panareti. If anyone came to the bank and wanted a mortgage along these terms, we'd have given it to them. I can take you to his evidence.
Well, don't worry, I don't find that very surprising evidence.
No. Well, at any rate, that was his. That was his.
There's a misrepresentation right there.
Quite.
Not unsuitable.
I think, in fairness to the learned friend, I should just rise and say that the bank itself, when it did make its presentation in these training seminars organised by the Alpha Panareti and by Roebuck in Cyprus, it presented a series of slides, the first one of which was exclusive mortgage deal for Alpha Panareti customers.
There may have been some sense, and it may well be that they had effectively pre-authorised these properties as good security.
What one needs to bear in mind, my lord, is that Alpha Panareti was a very big developer in Paphos, and therefore was likely to get some kind of preferential deal.
Yeah.
Mr. Papakristou said it wasn't. It was the kind of deal everybody got. The judge didn't accept that evidence because the evidence of the bank itself in its own slides to the agents was that there was an exclusive deal, and Mr. Papakristou eventually accepted that actually the bank head office had authorised the publication of those slides.
Anyway, you've not pleaded any representation that it wasn't really exclusive.
No, that at least is a relief. So I won't.
Okay, all right. Well, we've kicked this one.
Respond to that. But so far as Mr. Papakristou evidence is concerned, and for your note, it's at 1352 of the transcript. He was asked in cross-examination, were the bank officials saying that this was an exclusive deal for Panareti? Because in your witness statement, you said there were no special financing arrangements with Alpha Panareti. Do you want to reconsider the accuracy of what you said? Answer, no, what I said is correct. All mortgage housing schemes were available to everybody. It was not exclusive for Alpha Panareti. Question, so why are they saying it was exclusive for Alpha Panareti? Answer, I mean, the people that made the representation from Alpha Bank have to be nice. But I say it again, there were no exclusive housing schemes for Alpha Panareti. All the housing schemes are available to everybody. And that was the evidence. Now, insofar as the judge rejected that evidence, he didn't provide any reasons for rejecting it, other than to fasten upon what I submit was essentially the advertising puff of saying that the mortgage deal was exclusive. And I take on board that my Lord Justice Phillips regards my interpretation of that passage and brochures as tendentious. But the reality is the passage is capable of bearing that meaning, and it is consistent with what in fact happened. It was a product of the banks that enabled punters to borrow in order to enter into a purchase with Alpha Panareti. And the reality is that not everybody did anyway. You'll have seen from the orders that have been made in this case, and one or two references here and there, that there is a category of claimant in this case, or a non-Swiss franc loan and non-Swiss franc loan claimant. And they, for better or for worse, weren't persuaded that this exclusive deal was so wonderful, as described by the judge, that they had to leap at it. They made other arrangements. I don't know what those arrangements were, because those claims haven't been pleaded out and may never be. But the reality is that whilst a description of the mortgage was, as we've discussed many times, it plainly and in the clear light of Mr. Christodoulou's evidence, cannot properly have meant anything significantly more than, here's a deal that we have negotiated with the bank, and you can take advantage of it to buy this property. But as the non-Swiss franc loan claimants prove, you don't have to. And that's how I say that the marketing actually worked. That's not the approach that the judge took, as we know from the terms of his judgment. It is, however, an approach that he should have taken in the light of that evidence, evidence that he did not take sufficient account of.
So we have to reject. We have to find he was wrong to reject that evidence.
I'm sorry, I didn't quite.
We have to find that he was wrong to reject that evidence. Or that he was wrong not to take it into account.
What, Mr. Papandreou's evidence, whatever his name is?
Mr. Papachristodoulou's.
Mr. Papachristodoulou's evidence.
Yeah.
But he rejected it. And he rejected it on the basis that it was contrary to what's on the face of documents. So what is our basis for saying that he was wrong to do that?
Because whatever the face of the documents say, what you do have is the man from the bank himself, who was at least in part responsible for the product and for the way in which this matter was put out to companies and to the public, saying everyone's available. It's available for everyone.
Why is his evidence any more reliable than what was said on the face of the document?
Because on the face of the
because he's a man who's acting for the bank.
Yeah.
That what it amounts to.
May I just try to clear this up terribly quickly? If you'd go to page 582 in this supplemental document, it's tab 82, starting at 578, is the presentation of the bank in relation to Arcadia. And it's in the training session to the agents.
Tab 82.
And 582 is the particular page in that sequence of slides.
Yes.
And Mr. Papachristodoulis said that these presentations were authorised by head office, and the judge didn't accept his evidence that they weren't exclusive. I mean, there you go.
Well, the significant point is that they were marketed to customers exclusively for Alpha Panareti. Now, does that cover your three essential points?
Not quite. Lord, there is more that I need to take you to, and it does focus on the role of the bank and the responsibility of the bank, and indeed the way in which want to look at it in this way. At paragraph 34 of the judgment, Sir Michael Burton came to a conclusion that the training that had been carried out had been, quotes, attended, I think was the quotation, attended by representatives of the bank. I submit, well, for the reasons contained in my skeleton argument, in particular, the submissions I make on ground 2 in my skeleton argument, that the bank's role was a significantly greater one than was accepted or acknowledged by the judge in that paragraph of his judgment. But of significance in my submission is the conduct of the agent, Miss Brown, Mrs. Wellesby, after the event, when seeking some redress in relation to her own customers' complaints against complaints in relation to the mortgage that had been entered into. And if you turn to page 780,
transcripts or the supplemental?
This is in the supplemental, forgive me. No, not quite. Sorry, the supplemental that was provided to me. 718, I'm sorry. 780. Yes, of course. Yes, thank you. I'm very grateful. It starts with the cover sheet at 781A, and the letter itself is 781B. And it's a long letter. I'm going to invite your lordships and your ladyship to read it. I'm not going to read it out to you. But it's Mrs. Wellesby, the agent, complaining to the bank about the position relating to the mortgage. Now, you might have expected, if the mortgage was an issue and an issue that was the responsibility of Alpha Panareti, that this letter might have been addressed to Alpha Panareti, but no. It's addressed to the bank, and there are bullet points of 781D that worth looking at. Alpha Bank's most fundamental flaw in the investment and respective arrangements is clearly the execution of the housing loan in Swiss francs. This is purely down to Alpha Bank, and only Alpha Bank is in a position to do anything about it. Alpha Bank failed to advise investors about the risks involved. Alpha Bank failed to educate the agents involved about these risks. Alpha Bank failed to advise investors when the Swiss franc was gaining momentum against the pound-euro. On the next page, 781E, the investors, due to lack of documentation, were not aware of the terms of the mortgage, including the commencement of mortgage payments 24 months later. Then there's a point about drawdown, which in the next paragraph, which isn't an issue in this case. Then there's the charging issue at the foot of that page. Alpha Bank have raised their margin over LIBOR despite the sales particulars clearly stating that mortgage is variable in line with Swiss franc LIBOR. Moves in line with LIBOR not at the window of the bank. And then there are remedies suggested over the page. But this is entirely consistent in my respectful submission with the fact that the bank, and it was always the bank that was behind the product, and it was the bank that was behind the training in relation to the product. And it was the bank that was in error. So it is being put by Mrs. Welsby in that letter for not having done that which it should have done.
It's a letter from somebody called Heather Brown.
Yes, sorry. So Heather Brown Brown is her maiden name. Welsby is her married name. She appeared at trial as a witness under the name Welsby, but her witness name was
Yes.
Brown.
And she is an agent who would have received a commission from Alpha Panareti.
Yes.
All right. I don't know whether now is, but would you at some point like to find a convenient moment for the 5-minute break we're going to have?
Now is as good as it.
Yes? All right.
Yes. Could you write down the? Just write down the. Yeah. Could you write pen?
Yes, so it's a higher
Yes.
Well, can you just write it down?
No, it's 270
Closing submissions are
Paragraph. Well, this is paper, and this is what supplement. What line numbers for an internal page?
Rise.
Carry on, Mr. Parker, unless Mr. Nathan's about to say something.
Well, I'm just looking at him to make sure.
No, sorry, I do apologise. I'm just trying to close up some of my files.
Yes, I could do with a tidy up here as well. Right.
Those are the criticisms directed at the bank that we've looked at in Miss Brown's letter. And it reinforces the point that I've been trying to make, that it was the bank that was entirely behind the product and was entirely behind the training in relation to the product. Now, you will have seen reference, and we'll have to look at it in a very short few moments' time, to what's been referred to as the Cyprus Bank letter. The letter that was dated October 2006, that was issued by Cyprus Bank and circulated to Alpha Bank, amongst others. And the letter which contained the warning that was never given. It's at 469 of the paper copy of the supplemental bundle. And you also have the pleasure of seeing it in Greek 471, should you wish to. But at 469, dated the 11th of October 2006, Central Bank of Cyprus, to all banks established in Cyprus, there's been a large increase in foreign currency lending during the first 8 months of 2006, which exceeds by far the corresponding increase in lending in Cyprus pounds. Lending in foreign currency exposes borrowers to interest and foreign exchange risks. We emphasize that in the event of the interest rate of the foreign currency increases, or exchange rate of the foreign currency strengthens against the Cyprus pound, the loan payments of the borrower will increase considerably. We call upon the banks, therefore, to advise their clients about these risks. Specifically, before granting a loan in a foreign currency, the banks must take the following actions. 1, customers must be informed in detail on the exchange and interest rate dangers of borrowing in foreign currency, in contrast to borrowing in Cyprus pounds. This briefing should, without fail, be accompanied with separate numerical examples which explain how the loan repayments will be affected by a potential increase in interest by 1% and a change in the exchange rate by 5% to the detriment of the borrower. After this briefing, if the borrower decides uninfluenced to proceed with the loan in foreign currency, the borrower will have to sign the attached statement, which will be kept by the bank. We'll look at that in a moment. In cases where the client's ability to repay is marginal, financing in a foreign currency should be avoided, since any change in the interest or the exchange rate may make the settlement of the loan impossible. 3, when evaluating new applications, the maximum acceptable repayments as a percentage of their income should be calculated on a hypothetical base if the requested loan is granted in Cyprus pounds with an interest rate of the Cyprus pound. All of the above must also be applied when converting existing loans from Cyprus pounds to a foreign currency. And the statement over the page, not a very good copy, with the present statement, I declare that during the process of being granted a loan with account number X, I've been made aware of the exchange and interest rate risk I'm exposed to, exchange rate of the whichever currency it is against the Cypriot pound, and an increase in the interest rate of the foreign currency. Specifically, I've been informed that in the event of exchange rate changes so that the value of the currency in which I'm borrowing increases by 5%, my loan repayments will increase from X to Y. Furthermore, I'm informed that in the event of an increase in the interest rate of the currency in which I'm borrowing by 1%, my loan repayments will be increased from A to B. Despite the above risks, I decide uninfluenced to proceed to take the above loan in whatever the currency happens to be. Now that was dated the 11th of October 2006. I'll come back to that in one moment. Before I do that, I do want to take you to a passage of Mr. Pollard's cross-examination. It's a page that I had interposed, or asked you, I should say more accurately, to insert into your transcript paper bundles this morning. And it's pages 481 and 482. And I asked Mr. Pollard some questions about the foreign currency exchange risk, picking it up at internal page 131 at line 7. You refer to foreign currency exchange risk, page 119, top paragraph. You see that? Yes? Now, we know that the foreign currency exchange rate wasn't even mentioned by the Cyprus Central Bank until October 2006, which is very close to the end of your formal relationship with Alpha Panareti. Yes. And very much in a time when you were being eased out, isn't that right? Yes. It's hardly surprising if prior to October 2006 the foreign currency exchanges had been mentioned, and his evidence had been that this is an issue that had come up before that date, because it hadn't been identified even by the central bank, had it? It was mentioned in the context that it was low interest. The reason the Swiss franc mortgages were promoted was because they were low interest loans, and that was mentioned an awful lot. Right. But the exchange risk that was identified by the central bank wasn't made known to anybody until October 2006, by which time I suggest you'd pretty much stop going to these various dinners, and these are agents' dinners at which issues were discussed. Pretty much stopped, yes, pretty much. If you had pretty much stopped going to these dinners by then, it's hardly likely to have been mentioned at the dinners to which you did go, because they were before the Cyprus Bank warning. Do you see? I see where they're coming from. So then, why did you mention in your statement that the foreign currency exchange rate hadn't been mentioned, when the reality is that there was nothing to mention at the time that you were going to these dinners? It says because no one spotted it, I guess. It was never mentioned. It was a risk. We should have known that. We didn't know that. Well, it wasn't a risk that had even been spotted by the central bank. He said it wasn't. It was never mentioned. That's what I'm saying. Are you saying that even though it hadn't been spotted by Cyprus Bank, it should have been spotted by Alpha Panareti? Is that what you're saying? No, I don't say that at all. I don't think Alpha Panareti were any the wiser. And the judge said, so you're not being critical by this sentence? He said, no, I'm not being critical. So the judge said I could ignore it, really, and he said, yes. And so we moved on. So the evidence seems to be that Mr. Pollard gave somewhat equivocal evidence as to whether any warning was exigible prior to the Cyprus Bank letter of October 2006. And he seems quite clear that no one in reality had any idea of what the risks might be prior to October 2006. Certainly not him, certainly not Alpha Panareti, and nothing was coming from the bank to provide a warning in relation to the currency bet, as it's being called in these proceedings. What then happens after October 2006 is
the fact that the central bank don't send out this letter doesn't mean that they are not aware of the risks of somebody borrowing in a foreign currency. I mean, if you borrow in a foreign currency, it's perfectly obvious to anyone with any understanding of how these currencies work that you're taking a currency risk, isn't it?
Well, evidently not, because if it had been obvious, then the those who worked in the financial services business, who were the agents, it doesn't appear to be obvious to them.
So they were selling or introducing, is a neutral term, to customers with UK assets and UK pounds and sterling assets and income.
Yeah.
That they would borrow in Swiss francs.
Yeah.
And it didn't occur to them that was a currency risk.
So it would appear, and so the evidence would appear. Not one of the agents said anywhere in their evidence that either that they gave advice as to the currency risks, nor that they were required to or given any reason to do so.
Oh, but that's a different thing from whether they knew there was one.
Well, as to whether they did or didn't, there was no evidence at all.
Right, so the inference could be drawn that they did, because that would be the obvious inference to run.
Well, with respect, I would have thought the opposite would be the obvious inference to run. If the fact is that no one has said a word about it at all, notwithstanding that, and that includes the bank, certainly prior to October 2006.
Bank assumes that the obvious is going to be available to other people who are involved in the business, but it's not necessarily going to be obvious to the man in the street.
Well, yes, at the moment I'm not dealing with the man in the street, I'm dealing with the agents.
Quite.
Who
are independent financial advisors.
Yes, and it's the independent financial advisors, as your ladyship quite rightly emphasises, that don't know themselves, or just...
Well, stop eliding, please, the evidence. You've shown us evidence that they didn't say anything about it. You've shown us evidence that certain people said that it didn't occur to them to say anything about it. But where is the evidence they didn't know about it?
Well, there is no evidence that they didn't know about it.
Correct.
Except that insofar as the Cyprus Bank letter came out in October 2006, the evidence also is that, I'll put that slightly differently, there is no evidence to suggest that even that was shown to them.
But hang on, sorry, what all the Cyprus Bank letter is doing it's arisen because the bank has realised that over an 8-month period that foreign currency lending has exceeded by far corresponding increase in lending in Cyprus pounds. This wasn't the bank suddenly waking up to the risk of foreign currency lending. It was the bank waking up to the risk that there was a huge amount of it going on, and presumably significantly driven by your client's business.
Well, that is an assumption that one...
Or in part driven by your client's business.
In part, perhaps.
So this is, I don't think you can rely upon the fact this only came along in October 2006 as somehow saying at that point everyone woke up to foreign currency risk.
Well, I do, and I put it this way because I would submit this is not the bank simply saying you must now advise these people because we've realised that there are a lot of Swiss francs coming into the country or Swiss franc loans being made in this country. Because if it had simply been that, then the central bank would say to thousands, stop it. Just stop it. They're not saying stop it. They're just
what they're concerned about. They're concerned about Cypriot citizens who are borrowing in foreign currencies, which is why they're asking people to sign an undertaking to show that they've been explained how it will affect their position in Cyprus pounds.
Yes, that's absolutely right. But the concern is borne out.
It's not addressed at UK citizens at all. It's not addressed at UK citizens at all.
Well, it's addressed to the banks that are making the foreign loans.
But that's not the Bank of Cyprus's concern. It's concern for its citizens that it appears that there is a huge amount of foreign currency borrowing. So they are requiring Cypriot banks to ensure that Cypriot citizens sign statements to make it plain that they have been made aware that when they borrow in a foreign currency, they are exposed to greater Cyprus pound exposure. That's all this letter is doing.
Well, I would, with respect, read the letter slightly differently, and I would read it this way: if that was the sole concern of Cypriot Bank, of the central bank, then the remedy for the central bank is to write to the provincial banks, if I can put it that way, and say, stop, just don't do this anymore.
No, they're not concerned.
Because
They're not concerned.
there's-
That's not their concern at all. Their concern is that customers must be informed. And they're concerned that this is being done to the detriment of Cypriot borrowers.
In my submission, their concern is that there is plainly an imbalance, and that imbalance needs to be rectified.
But that is where they would then possibly have tried to introduce some restriction.
Yeah.
Though whether that in the European Union would be lawful, I don't know.
No, well, not
But that's not what they're doing at all here. There's no suggestion of, there's no express objection as to the practice. Their concern is that customers are properly advised as to the currency risk. Well, the letter's there.
Well, in my respectful submission, my Lord, I don't read it the same way. I read it in the following way, that if what they are saying is there is an imbalance that we are concerned about, then the obvious thing to do is to tell the banks as best it can to stop, or at least to cut it down. If, however, they are saying there's a lot of this about, and you need to realise that there is a foreign currency, that there's a risk from lending this time, then make sure you advise your clients properly. And it's that latter interpretation which I say that they are now putting out. They're saying, do you know, there's a lot of foreign currency going on, and foreign currency lending going on, and it's a risky business. So please make sure that your clients know.
Yes.
Yes.
It doesn't presuppose that they don't already know that it's a risky business, and that's the problem with your thesis.
Well, of course, we don't know what they knew prior to that date, and we don't know what anybody knew. But the assumption that the judge made in my submission was that it was absolutely obvious to anyone who had the first idea of lending in a foreign currency from the dot that it's a crazy thing to do, or I put that.
No, it's a risky.
It was a risky thing to do.
No, forgive me. All it is that there is a risk. That there is an added risk, which a customer should be made aware of.
Well, what is your case? Is it your case that your client did understand or did not understand the risks to a UK customer of borrowing in Swiss francs?
My case is that my client was completely in the dark about that, and he was completely in the dark about that because he wasn't given the.
He's a property developer.
Exactly.
He must be buying goods and possibly services from abroad in foreign currencies.
Well,
You must understand currency
So
risk.
but your case then is that your client put together an exclusive special deal which it did not understand.
I'm saying that my client put together an exclusive special deal which had components that were provided by specialists, and the specialist mortgage component was put together by the bank. The specialist legal component, so far as the conveyancing and the powers of attorney and so forth, was dealt with by the Cypriot lawyers. The specialist admin component, among other things, was driven by Roebuck, and the building component was provided by Alpha Panareti.
all very interesting, but that's just moving away from the question that you were asked, which was, did your client understand the risk or not? It seems to me that the natural concomitant of what you just told, my lord, which in my case was that my client was completely in the dark, is that he didn't understand the product he was selling.
And he didn't need to, because the product that he was selling was the bank's product, upon whom he was perfectly entitled to rely.
So he was entitled to go out and get agents to sell to various other people a product that he didn't understand, and that only the bank understood, without acquainting himself with it first to find out what it actually meant, and leaving it to the ultimate punters to ask the bank if they didn't understand it.
Well, I don't put it quite as starkly as that, but I mean...
Well, that's what it boils down to, though.
Well,
Really?
I would dispute that, lady, with respect to that. An entrepreneur who sells a highly technical product relies on the highly technical people that he has surrounded himself by to ensure that the highly technical product that he is selling does what it says on the tin, and it is capable of being explained by those who need to explain it. It doesn't follow from that that he has to understand the highly detailed technicalities of it himself, any more than I would respectfully submit Mr. Ioannou, on behalf of Alpha Panareti, is expected to understand the ins and outs of the mortgage product, the strengths and the weaknesses of the mortgage product that is being provided by Alpha Bank, and upon whom he is relying to ensure that the salesmen are duly trained in order to promulgate it.
Now, the judge's findings at paragraph 37 expressly don't depend upon this letter that you showed us.
Entirely.
So, although you can make your points about the timing of it, what the judge is saying is that essentially the points which it makes should have been known to Alpha Panareti, whether they were or not.
That is what the judge is saying, and what I'm saying is that he has no basis, or he had no basis to come to that conclusion, other than to sit back and say, as he did, well, it's obvious. And the problem was that it doesn't appear, at least until October 2006, to have been obvious to anyone. It doesn't appear from their conduct to have been obvious to the IFA salesman. It doesn't appear from its conduct to have been obvious to Alpha Bank. And of course, after October 2006, it still remained not obvious to anyone, because for reasons that none of us has been able to get to the bottom of, the Alpha Bank letter was never shown to the agents. They didn't. There's no evidence to the effect that they had it or were shown it or knew anything about it. And the most that can be said is, as the judge ventured at. Just need to find the.
It's paragraph 36, isn't it? He says it seems highly unlikely
Yes.
that it would not have been at the October Cyprus training session attended by Mr. Ioannou.
Well, indeed.
It's double negative, but essentially it's a finding that it was there.
Well, it is, and there's simply no basis for it. There's simply no evidential basis for him coming to that conclusion whatsoever. And indeed, the only Mr. Ioannou was not asked about that in his evidence, but in another passage of his evidence, he did indicate how it is that he came to the understanding that of matters to do with the financial aspects and the complaints related to the financial aspects of the case against him, and we can pick that up from his evidence. I just need to find the reference. Sorry, Mum, if you just give me one moment.
Can't see, certainly the witness statements we have in the bundle, I can't see that Mr. Yano dealt with the Cyprus letter at all.
No, I don't believe he did.
Doesn't really mention the currency risk
at all. No, he didn't deal with it in his evidence, and he wasn't asked about it. But so far as his understanding of the financial aspects is concerned, I could take you very briefly to his cross-examination, more accurately the timing of his understanding of the financial aspects. I'd take you to his cross-examination at 1019, page 1019 of the extracts bundle. And I pick it up at internal 49. There's questions by my learned friend, cross-examining. Line 7. Do you see this? Some in-house training material which was provided by ROP UK to the agents in Heather Brown has said that this was kind of material that was provided to her, for example, as an agent as part of the training. Look at the top page. Quotes, unique investment proposition, exclusive mortgage deals, interest rate from 3% up to 80% loan to value plus extras, interest-free option, close quotes. Loans up to 35 years there. Quotes, no stage payments, decision in principle within 7 days, exclusive purchase incentives, low deposit, pre-release prices, close quotes. Packages where something completed, occasional rental, and the judge then added, in quotes, free packages when the site nearly completed. My learned friend continued, occasional rental, something or other guarantee. The judge guarantee. And then my learned friend, for ROPUC clients only, exclusive support package, reduced legal fees through panel of English-speaking solicitors and bank work through a power of attorney, no need to leave the UK, tax information and support, exclusive ROP facilities, rental services and resales. And then the question. What I want to focus on is the top part. ROP UK clearly had in mind, did they not, that what they were offering was something which was exclusive. The only people they could have got that from was you, Alpha Panareti. And the answer was, Mr. Nathan, we've disclosed this piece of paper. Yes, I know you have. That's the next thing I was going to come to. The reason we have disclosed this piece of paper is that we didn't have it until some of your claimants have reported to the Consumer Director in Nicosia for fair closed contracts, unfair contracts. And through them, they have disclosed for comment these pieces of papers. Till then, I didn't have any knowledge of those, and I have to comment to say that whatever they say there, it has nothing to do with Cyprus. Question, it has nothing to do with Cyprus. Answer, I don't know if there is a loans up to 35 years, and I don't know if the interest rates on the mortgage, not the loans, because they are different things, as I said to you, is 3%. Also, no stage payment. This is totally brand new to me when I saw it. Also, the involvement of the lawyers. The rest of the stuff that they say, which is occasional, now that they have changed it to information-only rental income, they say occasional rental guarantee. That was the first time ever that I've seen those words, and therefore, another question, but that's what no progress payments, because the money they've been paid out by the bank through the loan, but they were not actually obliged to pay any money back to the bank until 1 month after the property had been handed over. Do you agree? And he says, that's your interpretation for the first time, I understand that. And pausing, stopping there. He's being asked by a document that is substantially quoted from in that passage. But what he makes quite clear is that his knowledge and understanding of the ins and outs of the financial elements of the package was not something that he carried with him throughout the entirety of this transaction, but only came to him in a documentary form in which he gets the opportunity to consider and what have you, at the time that a complaint was made by the various clients to the Consumer Council or Consumer Protection people in Cyprus, saying that they'd been the victims of unfair contract terms in terms of the purchases that they were making in Cyprus. Now, what we can see, and I don't think there's anything contentious about that, from the extracts of the Consumer Council documentation, you'll find it at 782A of the supplemental bundle, is that those complaints to the Consumer Council aren't made until May 2012, and in fact aren't made in a comprehensive way until August 2014. And this is years and years after the events with which we are concerned. And Mr. Ioanni's evidence was, in answer to cross-examination, I really was substantially in the dark as to the detail of all of this until at least 2012, if not 2014. Now, his answer doesn't specifically relate to the Cyprus Bank letter that we've just been looking at, the October 2006 letter, but it does relate to his overall understanding of the intricacies, if I can put it that way, of the financial elements of the package that he was providing.
The passage you just showed us doesn't seem to me to have anything to do with currency risks.
Well, what it has to do,
it talks about interest rates and when the loan is going to be repaid, which is a different point.
Well, it's correct that currency risk isn't specifically listed in the things that he's being asked about there. But what I submit you get from his answer is a distinct lack of appreciation of any of the elements of the financial elements of the package that he had been selling through the good offices of Roebuck and other ROP UK and others back in the day. His actual understanding of the ins and outs of that was extremely limited, and always has been, because this was an arrangement that had been put together with its distinct compartmentalized parts. And so far as the compartment that dealt with currency risk and the mortgage terms generally, that compartment, in my respectful submission, was one which was exclusively the banks.
We don't need to go. It's not a very subtle position, is it? The key thing here is Alpha Panareti put forward through its DVD and other marketing materials that it was offering, or it was putting forward the availability of a Swiss franc loan to UK-based purchasers to purchase Cyprus property. And that's all one needs to know in order for the person putting that forward to be aware of the currency risk. Now, I think at that point, Mr. Yanu, as an experienced businessman who no doubt deals with foreign currencies because he's building properties at an extensive rate, he would have to, it seems to me, the evidential burden would shift to him to say, I really didn't appreciate that there was a currency risk. And I think he would be met with a certain amount of scepticism by the judge if he'd said that. He'd certainly be met with some scepticism by me if you were to say that. And that's all one needs here, isn't it? We don't need to have him having a detailed understanding of the transaction. All we need him to know is that he was putting forward an Alpha Panareti loan to UK customers, which was denominated in Swiss francs.
Well, I suppose, taking it to its most basic, our objection on this side to the judge's finding that it was obvious, and plainly to your lordship's impression, if I put it at least as low as that it was obvious, is that there was no evidence adduced at the trial as to the obviousness of the risk at all. It was...
Well, that's the sort of thing that one doesn't have to reduce in the commercial court.
Well, we would say differently in circumstances.
Well, it's your appeal. You've got to show the judge is wrong.
Yeah.
And I think forgive me, but just saying to us, well, the judge was wrong on this, I just don't see where you're going to get on an appeal where the judge found it was obvious. I can't see any reason to disagree with him on that. And where are you going to get appealing that decision? And most of what you're doing seems to me to be trying to re-argue the case as though we were a first instance tribunal. And we're not. The judge has made these findings. At the moment, showing us all this material doesn't seem to me to... It's not a matter of you're not succeeding in overturning him. All you're doing is putting forward the arguments which he rejected. Where does that get us?
Well, what I'm seeking to do, evidently I've not done so persuasively enough yet. What I'm seeking to do is to demonstrate that the judge's findings were not consonant with the evidence that was before him.
If you're saying that there needed to be evidence in the commercial court that a businessman, it would be obvious to businessmen and financial advisors that there would be a currency risk when UK asset-based customers are borrowing in Swiss francs. I don't think any commercial judge, I don't think any commercial court judge or any judge full stop would have any difficulty in saying that there was such a risk and that it was obvious.
I can understand, or I could understand, if your case had been that, well, of course there's an obvious risk, and naturally I would have thought that any customer thinking of buying a property in Cyprus and taking out a Swiss currency loan would understand that, but the judge found that these consumers didn't, and that's not the way you put your case anyway.
I can't.
You're saying that this was a compartmentalised arrangement, and the judge was wrong to find that it was your client who was driving the train.
Yes.
Yeah. Okay. Well, I think we understand that.
Yes. I think probably that being so, I mean, I don't think that I will. I don't think that anything else that I had in mind to say would actually amount to anything other than repetition.
No, well, I don't think we need to repeat because we do that.
I know you wouldn't thank me for that. So, my Lord, unless I can help you any further, those are my assumptions.
Well, I think rather than ask Mr. Nathan start at 4:05, since we are making good progress. We'll adjourn now and resume tomorrow at 10:30.
Court rise.
Just